5 seconds to go. Start. This appeal arises from the judgment and order passed by the High Court of Tripura in regular first appeal number 28 of 2019 dated 29th July 2022, by which the High Court allowed the appeal filed by the respondents herein, original defendants, and thereby quashed and set aside the judgment and decree passed by the civil judge West Tripura Agartala, granting specific performance of agreement of sale entitled suit number 135 of 2016 instituted by the appellant herein, original plaintiff. Facts giving rise to this appeal may be summarized as under. The appellant herein, original plaintiff, instituted case number 135 of 2016 in the Court of Civil Judge Senior Division, Court number 1, West Tripura, Agartala, and prayed for the following reliefs: a decree for declaration of the entitlement of the plaintiff to get the execution, registration, and possession of the suit land from the defendants as part performance of the contract following the registered deed of agreement for sale dated 27th May 2016. A decree for mandatory injunction directing the defendants to execute and register the sale deed in respect of the suit land in favor of the plaintiff and to hand over the possession of the suit land to the plaintiff as a part performance of the contract in pursuance of the deed of agreement for sale within a specified period, failing which to execute and register the sale deed in respect of the suit land in favor of plaintiff and to hand over possession of the suit land to the plaintiff through the learned court by enforcing the decree as may be passed. A decree for permanent injunction restraining the defendants and their agents from making any kind of transfer of the suit land to others or to give any mortgage, lease, etc. of the suit land till disposal of the present suit. It appears from the materials on record that the husband of the respondent number 1 herein and father of the respondent number 2 herein, namely late Prabha Ranjan Das, was the lawful owner of the suit property. The appellant herein entered into a registered agreement of sale dated 27th May 2016 with respect to the suit property. The total sale consideration fixed was of rupees 17,50,000 only. An amount of rupees 4 lakh only was paid to late Prabha Ranjan Das by the appellant herein towards earnest money. Prabha Ranjan Das passed away on 5th July 2016, leaving behind the respondents, original defendants, as is lawful heirs. The appellant herein called upon the respondents herein to execute the sale deed in accordance with the terms of the agreement of sale dated 27th May 2016, duly executed by Prabha Ranjan Das. The respondents herein declined to execute the sale deed. In such circumstances, the appellant herein was left with no other option but to institute the suit seeking specific performance of the contract. In the suit, the trial court framed the following issues: is the suit maintainable in its present form and nature? Has the plaintiff any cause of action to institute the instant suit? Has the plaintiff entered into a registered agreement for sale dated 27th May 2016 with Prabha Ranjan Das, predecessor of the defendants, to purchase the suit land? Are the averments available in the plaint in respect of readiness and willingness to perform the part of the contract in its true construction sufficient to enforce specific performance as prayed for. Is the plaintiff entitled to get a registered sale deed in terms of agreement for sale? Is the plaintiff entitled to get a decree as prayed for? What other reliefs the plaintiff is entitled to? The suit ultimately came to be allowed in favor of the appellant herein, vide judgment and decree dated 20th November 2018. The operative part of the order passed by the trial court reads thus: in the result, the suit is decreed with cost in favor of the plaintiff with following directions. The defendant number 1, Shrimati Bandhana Modak Das, shall execute a registered deed of sale on behalf of herself and also being the guardian on behalf of her minor son, that is defendant number 2, Master Diptanu Das, in favor of the plaintiff Shri Parswanath Saha for the suit land measuring 1 Ganda 1 Kara of land along with building thereon measuring 529 square feet appertaining to Khatian number 347 having RS plot number 151 within a period of 45 days from the date of drawing up of decree, failing which the plaintiff will be entitled to get the sale deed executed through this court as per law, subject to payment of rest consideration amount of rupees 13,50,000 only by the plaintiff to the defendants. The defendants shall hand over the possession of the suit land to the plaintiff immediately after execution of the above mentioned sale deed along with all the documents of title relating to the suit property which are in the defendant's possession or power. Prepare decree accordingly. My court is hereby directed to prepare the decree in the light of my above judgment and to place it before me for my signature within 15 days from the date of passing of this judgment. Make necessary entry in the trial register. Thus, this case is disposed of without contest. The respondents herein, original defendants, went in appeal before the High Court. The High Court allowed the appeal essentially on the ground that late Prabha Ranjan Das was unable to foresee the hardship that would be caused to him and the family at the time when he executed the agreement of sale with respect to the suit property. The High Court accepted that late Prabha Ranjan Das executed the registered agreement of sale with respect to the suit property and had also accepted rupees 4 lakh only by way of earnest money. However, as stated above, the High Court took the view that the defendants have been able to establish that except the suit land, they do not have any other property, and if they had to part with the suit property, that would cause lot of hardship to them. The High Court, while allowing the first appeal filed by the defendants, observed as under. Apart from the aforesaid facts, we find that the submission of learned senior counsel appearing on behalf of the plaintiff that the defendants have not pleaded the fact of hardship in their written statement is not correct. The defendants have specifically stated in their written statement that except the suit land, they have no other piece of land and they require the suit land for their own residential purpose and they cannot expect to dispose of their only piece of land and building standing thereon, which would render them homeless, shelterless, and roofless. This pleading is also supported by their evidence. Even from the evidence of the witnesses of the plaintiff, it is established that the defendant number 1 used to reside in the house of her father at Beltali. Stop.